and it is a nuisance trying to fight the leadership of the country. In fact, a Western plot for regime change. I mean, these things are being said. What is your perspective?
Well, from the victims' perspective, I'm speaking.
Yes.
They know that it's been 2.5 years since Mr. Kenyatta was summoned to The Hague. At the time, he was Deputy Prime Minister and Finance Minister. He certainly wasn't head of state at that time. It's been 1.5 years since charges were were confirmed against him. Now, it was after he had been committed for trial that he chose to run for election. It's important to keep that in mind.
Right.
Furthermore, it's important to keep in mind that the history of the ICC's intervention in Kenya. Remember that after the post-election violence, the African Union sent Kofi Annan, Benjamin Mkapa and Graça Machel here to Kenya.
Yes.
They recommended, among other things, the establishment of a fact-finding commission. That was headed by Justice Waki. Justice Waki wanted a domestic tribunal. The ICC was his idea of a last resort.
Right.
Kofi Annan wanted a domestic tribunal. The ICC was only as a last resort. It was because and President Kibaki and Prime Minister Odinga, they agreed with this concept and they asked Parliament to set up a domestic tribunal. Parliament twice said no. Don't be vague, let's go to The Hague. So that was the reason why these cases ended up before the ICC. And indeed, the ICC cannot interfere in a domestic prosecution if there is a credible prosecution already taking place at the domestic level. So I believe that once you look at all these facts, which preceded the ICC's involvement, it's difficult to argue that this is some kind of neo-colonialist threat or neo-colonialist plot of regime change.
There's a question here from Gishara from Ruiru. Says, we victims are the ones who elected Uhuru and Ruto, so if they are jailed, there will be no peace in Kenya.
Certainly, this argument applies not just to Kenya. In most cases where international justice gets involved, somebody makes the argument that if somebody is jailed, if somebody is convicted, if somebody is acquitted, there might well be violence as a result of that, because you're never going to please all the people all the time. Some people are going to be extremely angry if a conviction takes place. Some people are going to be extremely angry if an acquittal takes place. Some people are going to be very angry if these trials are suspended by the Security Council, and some will be angry if the trials aren't suspended by the Security Council. So peace and justice are quite often in conflict with each other. But what we have to do as participants and lawyers before the ICC is to present the views of our respective parties to the trial chamber. The trial chamber takes the decision, having heard all of the evidence of the prosecution and all of the evidence of the defence. At the end of the day, the Security Council has a separate role. The Security Council can look at the peace versus justice debate, and it can issue a suspension for a maximum of 12 months, as I mentioned. So it's really up to the Security Council. If it wishes to suspend these trials, it does have the jurisdiction to do so. The victims are totally opposed to that, of course, but that is a power which is within the Rome Statute.
How many, of course, that is a question from a victim, or describes himself or herself as a victim.
Yes.
How many victims do you represent? And you have a list, or, it's just a group presumed to exist?
No, it's a very good question. The system of victim representation changed on the 3rd of October of last year. Prior to that, each person who wanted to be a victim had to fill out this 7-page application form saying exactly what happened to them. That application form was sent to the prosecution, to the defence. They had a chance to give comments on each application form, and then the judges would rule, having heard all of those submissions, as to whether each individual person was or was not a victim of the charges. It became obvious in the Kenyan situation, because there are thousands of victims involved in the case that I'm on, that this system wasn't going to work very well. There simply wasn't enough time, the judges said, to go through all of the forms and to take submissions from the parties. So they changed the system. They said no longer do the victims have to fill in this form. It's now up to the legal representative of the victims to represent the interests of all of the victims.
And in your case, how many are there?
The best estimate we have is approximately 20,000.
For the Kenyatta case?
Yes.
Alone?
Yes. Remember that during the post-election violence...
Okay, further to that, are these victims identifiable? These 20,000?
At the moment, we do not have a list of all of the victims. I certainly have not met more than a small percentage of the 20,000. Right. I've met a few hundred of those victims. But given that, under the government's own figures, over 600,000 people were internally displaced within Kenya, then the number who were subject to the crime of forcible transfer during the dates set out in the charges in Naivasha and Nakuru, according to our best estimate, is approximately 20,000. That's the figure we're running on.
All right. There's a question here. Somebody says here, I have a feeling that there are no genuine victims as for now, and that the proceedings are reminding us what we should forget. What do you say about that, Lord?
Well, I think I have yet to meet a person here in Kenya who denies that crimes took place during the post-election violence. I think everyone knows that, everyone accepts that at least 1,100 people were murdered, and that there were very widespread rape of women. There were terrible situations of forcible circumcision of men. There was widespread burning of houses and businesses. I don't believe that those essential facts are really contested by anyone. So if those facts happened to human beings, I think that answers the question. Of course there are genuine victims of
the question sequel to that is that people say we've sorted out this mess, we've sorted out the enmity between the communities that fought, time to move on, and that dragging on with this thing is taking us back.
Yes, well, I mean, that hasn't in fact been the formal position of the Attorney General or the Kenya remains a party to the Rome Statute. Kenya has domesticated the Rome Statute, and the Rome Statute provides for prosecution of those responsible for the crimes committed during the post-election violence. So to take what you're saying is that all of those who committed crimes during the post-election violence should be granted an amnesty. That's essentially what that argument is driving at,
right.
That we should move on, that there should be a complete amnesty for all those people. If that's the position, well then that will have to go through the relevant legislative process here in Kenya, and furthermore, the impact of any grant of amnesty within Kenya will have an impact on proceedings before the ICC, and it will be for the trial chamber at the ICC to receive those submissions in due course and to make its decision.
The way you speak seems to point to an assumption that there is actually evidence, and that the perpetrators of these crimes, that there is evidence. Do you, as a representative of the victims, have access to any evidence? Do you have any existing knowledge of suspects that are out there that are not being acted upon by the state?
Right, yes.
I mean, do you just talk theoretically that there are perpetrators who are among us? because the government the position is that, okay, the question then people ask is, why aren't they being prosecuted?
Yes.
The ordinary ones. If
right.
there's a challenge with the big fish.
Yeah. To answer your question, I do have access to a great deal of confidential evidence, which I'm not permitted to disclose.
Right.
Now, the question, is that evidence sufficient to prove the charges in this case, is a question to be answered by the trial chamber, not by me.
Yes.
They will make that determination at the end of the trial. Now, is there evidence suggesting that other people committed crimes during the post-election violence? You need only have a look at the WACI report to answer that question. I believe, I've made submissions to the trial chamber on this question. I believe that the lack of prosecution within Kenya is not in fact due to the absence of evidence. It is due to the absence of a will to prosecute. I've made that clear in my submissions. Of course, the question of Kenya's cooperation with the ICC has been litigated several times. It's been over 2.5 years since the Attorney General filed submissions, or rather the Government of Kenya filed submissions, saying that investigations were continuing in Kenya to the highest levels. The expression "to the highest levels" was repeated several times in those submissions. 2.5 years later, we have yet to see any prosecutions of individuals at the highest levels for the horrific crimes that were committed during the post-election violence.
All right, we just want to take a short break. We'll come back to continue on with this discussion. Very important for us to understand where the victims stand in the ICC case. We're talking to legal representative for victims in the Kenyatta case. That is Fergal Gaynor. We'll be right back. Don't go away. Send your questions in the meantime.